Good morning. Senate Judiciary Committee will come to order. And our first order of business today is to open the hearing on House Bill 2607, clarifying the time limitations for habeas corpus claims. With that, then, we will invite our first proponent, in-person conferee, Natalie Chalmers, Assistant Solicitor General, Office of the Attorney General. Please introduce yourself and welcome back to committee.
Still haven't learned. Okay, thank you, Chair, members of the committee. One day I will learn to turn a mic on. The purpose of this bill is essentially to clarify law that doesn't quite exist yet, although the Court of Appeals did recently rule on it. So 1507, just in case you're not familiar with it, is essentially when a defendant tries to say their conviction is unconstitutional. And typically what they're doing when they do that is they're saying that they did not have adequate counsel. And what happens on state law is that they are then allowed adequate counsel to represent them at the 1507 hearing.
Ms. Chalmers,
Yes.
Let me back up for just a moment.
Sure.
And if we could ask the reviser, Mr. Thompson, for a bill brief first, and then we will get back to your testimony. So apologize
Oh, no problem. Thank you.
for the out of order, but appreciate your patience. With that, then, we will ask our reviser, Mr. Thompson, for a bill brief. Thank you.
Thank you, Madam Chair, and good morning, committee. Ms. Chalmers is going to explain this really well because she actually deals with these cases day to day, but I'll give you the procedural background and a couple of notes. So this was requested in House Corrections and Juvenile Justice by Representative Owens, the chairperson over there. It went through House Corrections Committee and passed the House 120-0 after a small amendment was made in the House Committee, and I'll briefly touch on that in a second. So this does clarify the time limitations for habeas corpus claims. And as Ms. Chalmers was stating, that is a claim made under KSA 60-1507. And so that's the statute we're dealing with here. And these actions brought by prisoners that are in custody under sentence. That's what this statute is for. The bill adds a provision that requires certain actions to be filed within 1 year of the decision of the district court denying a prior motion under this section, or the opinion of the last appellate court, et cetera, whichever is later. So there's just a new time provision in here, which I believe will be explained very fully here in just a moment. And I'll just point out that the amendment that was made in the House Committee added a new subsection. It's at the bottom of page 2 that provides the amendments made by this act shall not bar actions under this section that are brought within 1 year of the effective date of the act. There was some discussion in the House Committee about whether the timing of certain actions that could be brought under current law might be barred under the change in the law. It might be a very small number of cases, and I think the conferees will get into that a little bit. But the House did make that amendment to give everyone basically a 1 year grace period to operate under the current rules. And the other thing I'll note is this would become effective on publication in the Kansas Register after the amendments that were made, rather than waiting until July 1st. And with that, I'll be happy to answer any questions and stand aside for your conferees.
Thank you, committee. Any questions for the reviser? Seeing none, then we will invite Ms. Natalie Chalmers back to the podium, Assistant Solicitor General, Office of the Attorney General. Please introduce yourself again and welcome back again to committee.
Thank you. My name is Natalie Chalmers. I'm an Assistant Solicitor General, and I do actually have an active caseload of 1507, so this is something that I do. Do you want me to just go from where I was before or start over?
If you don't mind starting over, we hadn't gotten far into it, but then it's complete in one go around. Thank you.
Thank you, Chair. All right, so 1507 essentially is...
And I think we're on 2607.
Yes, but the statute we're seeking to amend is KSA 60-1507.
Thank you.
And KSA 60-1507 allows actions which are called habeas actions, but essentially when a defendant is trying to challenge the constitutionality of their conviction. And most of the time, the challenges are that the defendant did not have effective assistance of counsel as required by the Sixth Amendment. As a matter of state law, when they get a attorney for that 1507 proceeding, that attorney also has to be effective. And so what we have then are 1507s of 1507 counsels. And this bill essentially clarifies the time limit for those. This legislator has previously enacted a 1-year time bar for all 1507s, but the problem is when we did what we call the Montrose fix after a Kansas Supreme Court opinion, one of the things you look at is whether or not the issue could have been raised before. Well, you can't raise that 1507 council was ineffective when they had yet to act. So this clarifies the 1-year time limit. The Court of Appeals has ruled that it would be logical to have a 1-year time limit. And so Raul, I'm going to say it that way. I don't know that that's how it's pronounced, but hopefully close enough. Raul does say 1-year time limit. This bill does differ slightly, and it was the reason the House amended it below. In Raul, they did 1 year from the mandate, which was when the Kansas Supreme Court clerk's office is essentially kicks something out and says, it's done, go back to the district court, or it's done. This will go off the date of the opinion, and the defense attorneys did want our bill rather than the Raul rule, but they were afraid that some defendants would not be able to get relief. So the House came up with the agreed upon amendment here, or at least the unobjected to amendment here. And that's how that happened. And what we're actually using is the date that goes with the federal habeas timeline, because in the federal habeas, it goes on the day that the opinion is issued and rather than the mandate. So the statute mirrors that rule. Unless there are questions, which I will stand for at the appropriate time, I have nothing further.
Thank you. Appreciate that. Are there any other proponent conferees in the committee meeting room or online? Not seeing any, then committee, any questions for our proponent conferee? I do have one. Thank you, Ms. Chalmers. I think you testified in this regard, but just want to make sure that the Office of Attorney General is supportive of the amendment made in the House Judiciary Committee. That's section G on page 2 of the bill.
Yes. This is Natalie Chalmers with the AG's office again. And yes, we came to a compromise. The defense counsel wanted the amendment, and we said fine as long as it was published or went effective in publication, so we have less people with a lengthy timeline to benefit from this.
Great. Thank you. Committee, other questions? Seeing none, then we will invite our, I'm sorry, Senator Corson.
Should have asked this to Jason, Madam Chair. I'm sorry. What was the vote in the House on this?
I think it was 120-0. If I have that right. Yes. Other questions? Seeing none, then we will invite our neutral conferee. Thank you, Ms. Chalmers. Appreciate your testimony and you appearing here today in committee. We will then invite our neutral conferee, Clayton Perkins, Kansas Association of Criminal Defense Lawyers, who is present on WebEx or not present at all? Not present at all. Okay, do we have written testimony submitted from Mr. Perkins? We do. Committee, in your committee folder, you do have neutral testimony from Mr. Perkins in your committee folder. Do we have any neutral conferees in the committee meeting room or online? Seeing none, then do we have any opponent conferees in the committee meeting room or online? Not seeing any. Then we will close the hearing on House Bill 2607 and thank our conferee again for appearing. And we will open the hearing on House Bill 2574, establishing a time limitation for awarding compensation for mental health counseling and increasing certain compensation award amounts by the Crime Victims Compensation Board. And we will invite our advisor, Mr. Thompson, for a bill brief.
All right. Thank you again, Madam Chair. House Bill 2574, as you mentioned, establishes some time limitations in regard to the Crime Victims Compensation Board and the work they do. This was requested in the House committee by the Attorney General's office on behalf of the Crime Victims Compensation Board, which is under their office administratively. The House Judiciary Committee passed the bill out, and the House passed the bill 121-0. So there's your procedural background. You may recall last year, the legislature did amend the statutes that are at issue in this bill. And so this may sound very familiar to you, and I think the conferee will get into some of the things that happened near the end of the session that maybe didn't get caught like they should have. And so a couple of these things are corrections to things that probably should have been done in last year's bill. I'll kind of leave that to the conferee to explain a little bit more, because some of it is more about how the board works and some things that maybe got struck in the current law that maybe should have been kept, and some mechanical things that they're very familiar with. The two sections here are KSA 74-7301. That's the definition section for the Crime Victims Compensation Board statutes. The key changes here are the definition of allowance expense. It's a total charge under current law for funeral, cremation, or burial services not to exceed $5,000. And the bill there on page 1 in line 15 increases that cap to $7,500. So there's an increase in the amount of the allowance expense for those funeral and other related expenses. There's also under current law a cap on the charge for crime scene cleanup expenses of $1,000, and the bill increases that to $2,500. That's the change on page 1 in line 22. So there are two increases in the allowance limit for these kinds of expenses, and those would be new policy choices that you're asked to make in the bill. And then section 2 amends KSA 74-7305. That's the statute that sets out all of the requirements for an application for compensation from the board. And that's the statute we really amended last year. And you're asked to expand, in a way, some time limits that are allowed for certain victims to claim compensation. Some of them were provided by the prior law. Some of them are a little different under this bill. So there's some nuance there. But essentially, what you're asked to do in the bill is to allow compensation for a victim who witnessed a violent crime when they were less than 16 years of age, if the board finds good cause for the failure to file within the timelines required, and the victim files before they turn 19. So if you have a particularly young victim, this would give them more time to file that claim. And further, some mental health counseling benefits can be awarded if an application was not timely filed, and these would be for victims of a sexually violent crime, and that's if the board finds good cause for the failure to file, and it's within 10 years of the date of the crime, or they were less than 18 at the crime, at the time the crime happened, and the claim is filed within 10 years of the date they turned 18. So there's a lot of little limitations in there that would expand the time for certain victims, especially those that were young at the time of the crime, to make claims for compensation. And hopefully that covers the basics. I think there's another note or two in, I guess I would say one final note from the bill brief is that there's a current law in subsection H that prohibits compensation to certain victims if the economic loss is less than $100, and the bill removes that limitation. So you could, under the new law, have nominal compensation of amounts even under $100 if that were what was claimed. So that's one other change I should probably note. And with that, I'll stand for any questions.
Committee questions for the reviser. Senator Pyle.
Thank you. Jason, on page 5 at the bottom and page 6, the stricken language, I notice it has human trafficking language. Can you explain what that strike is on bottom page 5 and top of page 6, please?
Madam Chair, Senator, that's the change I was just referring to there at the very end. So current law says, with some exceptions, economic loss less than $100 is not, you can't get compensation from the board for that. There are a number of exceptions to that you see there from 5 to 6. But the change that you're asked to make here is to just strike that provision. So compensation could be awarded if the economic loss was less than $100 if you adopt this. So right now, if I have a claim as a victim and I don't have, and I'm not a victim of one of those crimes listed there, and my claim is only $80 or something less than $100, the board cannot compensate me. That's how I read subsection H. And so now my claim, if it's only $80, I could get compensation for that claim. It wouldn't have to be over $100. And hopefully the board can clarify that a little bit more, you know, how that might help certain folks, whether they get a lot of those claims or none of those claims because they're barred. But this basically just says there's no floor. You don't have to have a certain amount of damages before you can get compensation. Whereas under current law, you have to have at least $100 or be one of the exceptions.
Thank you.
Committee, other questions for the reviser? I have one. regarding on page 4, line 24, victim is defined in KSA 7301M4. That section defines victim as a person who suffers personal injury or death as a result of witnessing a violent crime when the person was 16 years of age or younger at the time the crime was committed. Is that something that was enacted last session?
Madam Chair, I believe that is one of the provisions from last year's bill, and hopefully the representative from the board can clarify. If it wasn't last year, it is current law in any case, right? That is current law in 7305 on page 4. So that's all regular type, right? That's current law. And the definition on page 3, that is 7301 M4, that's also regular type. So that's current law. So yes, I believe if not last year, then in a prior enactment, obviously, that is current law, yeah.
And what is the time frame for a victim who suffers personal injury or death as a result of witnessing a violent crime when the person was 16 years of age or younger at the time the crime was committed? What is the time limit for that person to file a claim for with the Victims' Compensation Board?
Madam Chair, Jason Thompson again. So it gets a little complicated, so I might just give you the basic idea. The general rule is in subsection B. So except as otherwise provided, compensation may not be awarded unless an application has been filed within 2 years of the reporting of the incident to law enforcement, if the victim was less than 16 years of age and the injury or death is the result of any of the following crimes, right? So you've got then a list of exceptions. So 2 years and then some exceptions. And then B2 is compensation for mental health counseling may be awarded to other victims with other timelines, right? So you may remember you kind of bifurcated that at the request of the board within the last couple of years. I think that was last year's legislation. And actually that, I believe, even was reflected in prior law. There were certain limitations for compensation and there were certain limitations for mental health counseling. And then you kind of added new exceptions to each of those. But generally speaking, there's the 2-year concept is kind of throughout each of those. And hopefully the board can clarify if I misspoke on any of that, but kind of the general rule is 2 years, but there's a lot of exceptions.
Thank you. Committee, other questions? Seeing none, then we will invite our proponent conferee, Richard Samaniego, Chair, Kansas Crime Victims Compensation Board. Please introduce yourself and welcome to committee.
Thank you, Chair Warren, members of the committee. Can you hear me okay?
Go ahead and speak again and we will see.
Okay. Good morning, Chair Warren and members of the Senate Judiciary Committee.
That works. Thank you.
Perfect. My name is Richard Samaniego. I serve as chair of the Crime Victims Compensation Board. Before I get in too much detail on my testimony, I did want to reiterate Mr. Thompson is correct that those provisions regarding child witness victims was last year. And I'll get into that later in my testimony. But just a little background, the Crime Victims Compensation Board, the other board members are Stuart Hyde and Becky Dickinson. It's a 3-member board. We obviously, on behalf of the board, I do thank you for allowing us to present testimony on HB 2574. The Crime Victims Compensation Board assists victims of crime in Kansas with compensation for loss of earnings and out-of-pocket medical expenses as a direct result of a violent crime. The board also approves claims to assist victims' families with reimbursement of funeral, burial, and cremation expenses, as well as grief therapy related to a loss of a victim. The board meets once a month to review these claims and also to hear requests for reconsideration that are denied under the Kansas Administrative Procedures Act. I would be remiss if I didn't mention our great staff from the Attorney General's office that is on the front lines of processing these claims, and a lot of the information I convey to you is from them and what we discuss at our board meetings. Last fiscal year, the board paid more than $2.5 million to or on behalf of victims of violent crime. Payments for the victims are through the state Crime Victims Compensation Fund, as well as the Federal Victims of Crime Act, VOCA, compensation grant, which matches 75% of every state dollar spent for victims. Both sources are primarily funded through fines, fees, and penalties throughout the criminal justice system. The board recently met on August 12th, 2021, and unanimously supported the revisions proposed in HB 2574, which simply increases the statutory limits for certain claims that have not been updated for quite some time. For example, funeral expenses, the allowable expense would be increased to $7,500. The current limitation of $5,000 was last increased in 1998. The majority of funeral bills submitted to the board exceed this $5,000, with families having to pay any costs above that cap. Asked the executive director to kind of look at some of the most recent claims and where we're at, and we're seeing funeral bills averaging about $6,387.42, and a third of those exceeding the $7,500 proposed cap increase that we're requesting. The crime scene limitation of $1,000 was added in 2007 and has never been increased. Recently, crime scene cleanup costs have averaged about $2,500, but often exceed this amount as well. Crime scene cleanup, as you can imagine, is an extensive process, but necessary for victims and their loved ones who are likely not experienced in properly cleaning up the biohazardous materials. This is also a very traumatic process for the family if you've lost a loved one in a violent crime. The bill clarifies and broadens the provisions regarding crime scene cleanup expenses to help victims restore their homes after a violent crime. Currently, the statute defines crime scene cleanup as the removal of biohazardous materials, but does not authorize the board to replace materials. This has caused a lot of confusion and hardship for many victims. The proposed provision simply allows us to approve claims to replace carpet that must be removed due to it being biohazardous, or if it was damaged during evidence collection. This is presently allowable under the federal crimes compensation requirements if we allow it by state statute. Additionally, HB 2574 removes the $100 minimum for crime-related expenses before the board can pay a claim. For some victims, any expense presents a financial hardship, even if it's under $100, but also removing this minimum will improve efficiency of processing claims. Sometimes when you might be eligible for a claim, but the staff has to hold it until it exceeds $100, and that oftentimes those can be way down the road. And if a victim has an amount that needs to be reimbursed that's less than 100, staff would like to be able to give it to them instead of just holding it until that $100 threshold is met. Finally, HB 2574 provides a correction to restore provisions we believe were inadvertently removed with the passage of HB 2077 last year. HB 2077 has requested a broader good cause exception to improve mental health claims beyond the 2-year limitations for child victims. The section to be amended in KSA 747305 also contained an exception to the 2-year limitations for victims who file a claim within 2 years of testifying in a sexually violent commitment hearing, or within 2 years of notification that DNA testing of sexual assault kit has revealed a suspected offender. When 2077 was amended by this committee to provide a 10-year statute of limitations related to sexually violent crimes and child victims, I believe the existing language related to that, to those exceptions that were previous law, were inadvertently not added back in just on the way it was, the draft was amended. These provisions are vital to ensuring access to compensation for mental health counseling for victims at a very stressful time that may take place well beyond even the 10 years. In addition, I just have learned that the Federal Reconciliation Act that just passed does address some issues on the sexual assault kit initiative. So we're going to look into to make sure we are in compliance with that as well. But it's just I just wanted to point out the dynamic that it's kind of a symbiotic relationship between the federal fund and the state fund since they're matching. I want to thank you for the opportunity to provide testimony and request favorable recommendation of HB 2574. I'd be happy to stand for any questions from the committee.
Thank you. Committee, you also have in your committee folder proponent written only testimony from Lindsay Ford, Public Policy Attorney, Kansas Coalition Against Sexual and Domestic Violence, and from Ilsa Necht, Director of Policy and Advocacy, Joyful Heart Foundation. And with that, then, we will ask, do we have any other proponent conferees in the committee meeting room or online? Seeing none, then do we have any questions for our proponent conferee? Seeing none, then want to thank you, Mr. Samaniego, for your testimony today and for that very thorough briefing of the bill.
Thank you very much.
Thank you. Do we have any neutral or opponent conferees in the committee meeting room or online? Seeing none, then we will close the hearing on House Bill 2574 and open the hearing on House Bill 2537, requiring the Insurance Department to hold a hearing in cases involving an order under the Kansas Administrative Procedure Act, and have our reviser, Mr. Thompson, with a bill brief.
Thank you again, Madam Chair. So House Bill 2537 was requested in the House by Mike O'Neill, who is listed as one of the conferees, or maybe a conferee. I know he's here. I have trouble not calling him chairman from past experience, but I'll just note that. So House Judiciary did work this bill and pass it out, and then the House passed the bill 121-0. The amendment in the bill is to KSA 40-281. Statute we don't deal with often in this committee. It's under the insurance statutes. It authorizes the Commissioner of Insurance to hold a fact-finding hearing on any matter relating to the business of insurance. And it becomes a judiciary matter in this case because the issues are appeals under the Kansas Administrative Procedure Act and the conduct of hearings under that act. And so that's probably why it's under your purview here in this committee. The bill adds a new subsection D, which you can find on the top of page 2, that just provides that any person subject to an order as that's defined under the Kansas Administrative Procedure Act and KSA 77-502, that's issued by the commissioner may request a hearing on such order. If the request is made, the commissioner shall conduct that hearing in accordance with the provisions of CAPA, the Administrative Procedure Act, and then all other procedures kind of kick in from there. So under current law, there's a fact-finding hearing. It's not necessarily clear that it's an order under CAPA, subject to CAPA. This makes that perfectly clear in that new subsection. And then I'll let the conferees explain to you kind of the policy of how they're doing things now, how this might change it, and why that's a good idea or a bad idea. So happy to answer questions.
Thank you. Committee questions for the reviser? Seeing none, then. Do we have proponent conferees in the committee meeting room? I don't see any on the agenda, but Mr. Mike O'Neill is in the committee meeting room as a proponent conferee. So please introduce yourself and welcome to committee.
Thank you, Madam Chairman. Mike O'Neill with O'Neill Consulting. A little confusion with the testimony. This was actually scheduled for last week on Thursday when I could not appear. But today, thanks to the chair accommodating, I can appear in person. So I appreciate the opportunity to appear. I won't go into the details as to why I was not available last Thursday. Some of you may already have guessed that reason. Weekend did turn out pretty well. A little background, Jason did an excellent job of explaining this is a very simple provision, but it arises out of a couple of cases I handled for clients with the insurance department in which we had a good faith difference of opinion as to whether or not a hearing was required under the Kansas Administrative Procedures Act when the, in this case, the past insurance commissioner and then one case involving the current insurance commissioner issued letter opinion orders that were kind of one sentence and said, this is the final order and your remedy is through the Kansas Acts for Judicial Review. The problem that we had with that was when you go to district court, then if there's no hearing, then there's really not much of a record on which the district court can base an opinion. And in the case of the one under the prior insurance commissioner, that case actually got reversed because there was insubstantial evidence in the record to support the decision. And the insurance department then did schedule a hearing, but we settled that case in the meantime. And so moving forward for any other individuals that are involved in this, our position, so there's no specific statute that requires a hearing. In fact, there's a statute that says when a hearing is not required. And so this would clarify that. Our position was that any case involving an order that meets the definition under the Kansas Administrative Procedures Act 77502, an order meeting a state agency action of particular applicability that determines the legal rights, duties, privileges, immunities, or other legal interest of one or more specific persons, contemplates that there would be an administrative hearing under the Administrative Procedures Act. Since there's nothing currently that absolutely requires that, this finishes that out. I worked closely with Justin McFarland, the chief counsel with the Kansas Insurance Department on this. I think you have probably neutral testimony from the department. So they worked closely with us. And as Jason said, this passed unanimously on the House side. Nothing you do here today would affect the cases that I handled. This is just those cases brought to attention the need for some clarification in the statute. With that, I'd be happy to stand for questions.
Committee, this is the only proponent conferee that I believe is in the committee meeting room, but we will ask, are there any other proponent conferees in the committee meeting room or online? Seeing none then, committee, any questions for the proponent? Senator Gossage.
Thank you, Madam Chair, and thank you for being here. I did notice in the neutral testimony from the Kansas Insurance Department, they did say this bill would create a new procedural remedy, but go on to say the department believes this expansion would apply in limited circumstances. As you mentioned earlier, this is an unusual circumstance that the hearing would be needed, but nice to know that it's there. Does that make sense to you? And you concur?
Excuse me, Mike O'Neill. Essentially what it does is if it's a case that is going to result in an order that could be appealed under the Kansas Act for Judicial Review, if an individual who is potentially affected by that wants to have a hearing, they can request it and it shall be granted. But it's not going to be in every case that is required.
And one last question, if I may, Madam Chair, is so let's say that someone receives this order and then they would, after they've already received the order, they would have the right under this bill to be able to go back and say, I never had a hearing. Is this correct?
Yeah, generally what's going to happen is you're going to get the order and then you're going to request a hearing under the Kansas Administrative Procedures Act, and that's in Chapter 77. And there's a procedure for that. You need to do that within 30 days, and that's not amended here, but there is a whole body of procedure for those type of hearings.
Thank you very much. Thank you, Madam Chair.
Thank you. Committee, other questions? Seeing none then. We do have neutral written only testimony in your committee folder from Justin McFarland, General Counsel, Kansas Insurance Department. Do we have any neutral conferees in the committee meeting room or online? Seeing none, do we have any opponent conferees in the committee meeting room or online? Seeing none, then we will close the hearing on House Bill 2537 and thank our conferee for appearing today. Glad we could get that scheduled and work out to have you present. Thank you very much. Committee, then we will now turn to working and possible final action on bills previously heard. I would like to start with the resolution that we heard yesterday, HCR 5022, proposing a constitutional amendment requiring that a sheriff be elected in each county with one exception. If we could have a quick bill brief reminder from the reviser.
Thank you, Madam Chair. Jason Thompson, Revisor's Office. So as you may recall from yesterday, HCR 5022 is the proposed constitutional amendment requiring a sheriff to be elected in each county and providing an exception to that. This is the bill that passed the House 97-24. So there's your reminder of the procedure. the main change is to make the office of sheriff a constitutional officer. That would be in Section 2 of Article 9, where other county and township officers are defined in the Constitution. The election for a sheriff would have to happen based on the timing that's currently used as of January 11th of 2022. So if you had an election in November, it would be in November going forward. If you had it in some other time, it would be in that time going forward. And you would have a 4-year term, so it would happen every 4 years. The provisions of this constitutional amendment or of this new section would not apply to a county that abolished the office of sheriff prior to January 11th of this year. And that is only one county, Riley County. So it would not apply to them as the amendment is currently written and proposed. And the only other change is to clarify and put in the Constitution that you can only remove a sheriff involuntarily by recall election or by a writ of quo warranto initiated by the Attorney General. Under the current law, I think you were told those options both exist, but you can also have an ouster petition for the other term for quo warranto in this case. That could also be filed by a county or district attorney under the current law, and the constitutional amendment would prohibit that. It would only be by the Attorney General. I think those are the two main changes for you.
Thank you. Committee questions for the reviser. Senator Pyle.
Jason, I have a question. Okay, so constitutional officers which ones are subject to impeachment and which ones are not? Do you know?
Mr. Thompson.
Okay, thank you, Madam Chair. Just doing a quick look for the constitutional provision on impeachment. It's a limited number. So we're in Article, I believe it's Article 2 because it's under the legislative power, right? Section 28, officers that are impeachable. It says, the governor and all other officers under this Constitution shall be removed from office on impeachment for treason, high crimes, and misdemeanors, you know, the rest of the language. So the governor and other officers provided by the Constitution. And I'm looking to see, there's a specific reference to justices of the Supreme Court. And so they're specifically covered by that. I don't see a reference to the county officers. I think that provision is applicable to state officers, if my reading is correct. So the county officers are not currently subject to that Article 2 impeachment grounds. It's the state officers like the governor, the lieutenant governor, the attorney general, secretary of state, right? And those are the proceedings conducted by the House of Representatives. So that's the specific impeachment power.
Committee, other questions for the riser? Seeing none then, are there any amendments? Senator Wilborn.
Thank you, Madam Chair. I have an amendment. And while Jason is handing out the amendment, I just want to express my strong support for what the sheriffs do in the state of Kansas, their scope of service. They're accountable to the public. And this amendment is very simply moving the dates in which this will be subject to election, special election hereby called on August the 2nd, 2022, pursuant to Section 1 of Article 14 of the Constitution of the State of Kansas to be held in conjunction with the primary election held in such date. I might add that a number of members of the Sheriff's Association, along with their council, met with us and agreed to this amendment. If, for some reason, something should change, we can always change the date on the Senate floor. But hereby, Madam Chair, I move this amendment.
Thank you. Committee, is there a second? Senator Thompson. Committee, any discussion on the motion or the amendment? Yes, Senator Haley.
Thank you, Madam Chair. And I was just wondering if someone could refresh my recollection on how many, if this is adopted, how many measures would then already be scheduled. I know we've got the big question on, the pro-choice, pro-life one, but how many would this then? I know we have another one that's before this committee that we have yet to weigh in on the other two, the judicial nomination ones. But how loaded does this make then our primary, this August primary?
I want to clarify one part of that question. I don't think we have any other proposed constitutional amendments in committee. I believe all that have come through this committee have been passed out to the Senate as a whole. So this is the last proposed constitutional amendment in this committee. But with that, if Mr. Thompson could answer the question about how many are on the August 2nd, 2022 ballot already.
Madam Chair, Jason Thompson, Revisor's Office. Currently, there's one that has passed both houses and is on the ballot, the one that was referenced. There were two passed by this committee last week, but are not currently on the ballot, and this would be a third potential. So if you put all of them on the ballot, that would be four. The constitutional provision, I was just looking up, Article 11, Section 1, limits you to not more than 5 amendments shall be submitted at the same election. So if you put all 4 on there, you would be under the limit of 5.
Perfect. And Madam Chair, if I could, are there any on the November, are there any questions that will be put before the electorate and the general election of this year so far? I don't recall any, but.
There are not.
Okay.
And there is one on the ballot as of today for August 2nd, 2022.
So we have 2 yet to consider, which may then make it 4 if all were adopted.
I think there are 3 others currently below the line in the Senate as a whole that have not been brought up for debate in the Senate as a whole. And
Thank you, Madam Chair, and thank you, Mr. Thompson.
Thank you. Committee, yes, Senator Corson.
Thank you, Madam Chair. Just for my clarification, so the rules and regulations constitutional amendment, if that were passed appropriately by both chambers with the requisite number, that would be in November, correct, Mr. Thompson?
As it's currently written, it would be in November.
And then as it's currently written, we also have a proposed constitutional amendment that we passed out of the tax committee that was referred back to the tax committee. We just passed it out again today. That would, if adopted as currently written, that would be on the November 2022 ballot. Again, if it weren't amended as it's currently written, if it got the requisite number of votes. And that's the one about the 2/3 tax increase, 2/3 vote. So I guess my question about this is, what was the reason for moving it from November to August? We know that more voters vote in November, and I felt like what we heard from the testimony was this is such an important issue for Kansans. Kansans deserve to weigh in on whether they want to be required to elect their sheriffs. So it just strikes me that I thought November was more appropriate because we again know that voter turnout is always higher. That would give more Kansans the opportunity to weigh in and make their voices heard on whether they wanted to adopt this amendment. So I liked having it in November, so I'm just kind of curious the rationale in moving it to August. Thank you.
I think, candor, the moving it to August seemed to be more beneficial to the particular amendment in passing with a higher margin.
Thank you. Committee, other discussion on the amendment? Yes, Senator Gossage.
Thank you, Madam Chair. I would just say that we're have seen that there's been lower turnout in the primary, and I would love to see this be able to raise that number of the people that come out to a primary. Thank you.
Thank you. Committee, other discussion? Seeing none then, all those in favor of the motion signify by saying aye.
Did we have a second?
Oh, I'm sorry. We did have a second with Senator Thompson was the second. So let's have that motion that the motion is to amend. I'm sorry, do you want to close, Senator?
Thank you, Madam Chair. No other comments other than I move my motion.
Thank you. Committee, you all have heard the motion. Those in favor signify by saying aye. Those opposed, no. The motion carries. We are back on the bill. Committee, any other amendments on the resolution? Seeing none, then do we have a motion? Senator Thompson.
Thank you, Madam Chair. I move that we pass out HCR 5022 as amended favorably for passage.
Committee, second from Senator Gossage. Thank you. Committee, you all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. Next, we will turn to possible final action on House Bill 2516, which requires an offender who raises error in such offender's criminal history calculation for the first time on appeal to show prejudicial error, and requiring the journal entry used to establish criminal history to be attached to the criminal history worksheet, and authorizing the court to correct an illegal sentence while a direct appeal is pending. If we could have a bill brief from the reviser.
All right. Thank you again, Madam Chair. Jason Thompson, Revisor's Office. As you mentioned, 2516 does a number of things with offenders who raise errors. It's related to the criminal history calculation and how you challenge your criminal history calculations. This was requested by the Attorney General's Office, and it went through the House Corrections Committee and passed the House 121 to 0. I think other than the very high points of requiring that journal entries be attached in Section 1, requiring that when you're calculating the criminal history and an offender challenges that for the first time on appeal, they have the burden of designating things that show prejudicial error. And then in the final section, the ruling on a motion to correct an illegal sentence is subject to appeal. And there's a retention of jurisdiction, and there's a retention of authority to correct errors. Those are pretty much the high points. I'd be happy to elaborate if needed, but that probably covers it.
Committee, questions for the reviser? Seeing none, I do have an amendment. Committee, we will ask the reviser for an explanation of the amendment.
Thank you again, Madam Chair. Jason Thompson, Revisor's Office. So I labeled this one Judicial Branch. That may hopefully remind you where it came from. This was the discussion that was had by the representatives from the Chief Justice and also the District Judges Association. Their concern was that Section 1, the amendments in Section 1 would expand the requirements put on court services officers and the court, and they asked that Section 1 be removed, which would just keep current law. So that's what this balloon does. It would remove Section 1 from the bill, which keeps current law as it is with no changes. And in addition to that, on page 3, they asked in Section 2, the amendments to KSA 216814, that the first change there in subsection B in lines 19 through 24, that be undone as well. So that would revert back to the current law language of except to the extent disputed, the summary of the offender's criminal history prepared for the court by the state shall satisfy the state's burden of proof regarding an offender's criminal history. And the argument that they made and are asking you to adopt here is if you don't change Section 1, there's no need to change this provision either, and that keeps the current law intact as far as the preparation of the criminal history worksheet, the attachment of journal entries only if they're available, not required in all cases, and then that summary prepared by the court satisfies the state's burden, but it's subject to dispute in accordance with the current law as well. And that's also addressed in the new subsection D that's preserved in this balloon, right? How the challenges play out. So hopefully that explains. The other change I think is just to strike the reference to 216813 that we're no longer amending if you adopt this balloon. So.
Thank you. And Mr. Thompson, does the amendment make sure to preserve that the state has to meet its high burden of proof about past criminal history, and it doesn't, with the amendment, lower the state's burden of proof so that we preserve, it's always the state's burden to prove guilt in the criminal context?
Madam Chair, Jason Thompson, Revisor's Office again. So you're correct. This does not affect in any way the criminal burden of proof beyond reasonable doubt that the state provides or has to meet. And all of the current law in 216813 about preparation of the criminal history and how that is done would be preserved. And then all of the current law about how that is challenged and who has the burdens to dispute those, it's all preserved as well in the next section. So
Without the amendment, then we have our pre-sentencing officers have the obligation to put this report together.
Madam Chair, Jason Thompson again. So under the current law, court services officers and the court have the burden or have the duty under the statute to prepare a listing of all of your prior convictions for each offender. And I'll quote the language just because I want it to be exactly right. It includes any available source of journal entries or other documents through which the listed convictions may be verified. If any such journal entries or other documents are obtained by the court services officer, they shall be attached to the pre-sentence investigation report. So under the current law, those are used to verify the history, and if they have them, they're required to attach them, but they are not required to go out and get each journal entry. The bill would require the court services officer and thus the court to find and attach every journal entry. And this would undo that change, that proposed change, so that you're only attaching those that you do acquire, if that makes sense.
And the bill without the amendment would require the court services officer to try to go to all other 49 states to determine if there's prior criminal history to attach to the pre-sentence investigation.
Madam Chair, Jason Thompson again. We did hear that was potentially one option. If you did the sort of the normal hit of the databases and you retrieved a conviction, you would have to go get that journal entry. So that was certainly provided, but there was also some discussion about whether there would be more searching needed, even if there was no hit. You might need to go verify whether or not there was a journal entry, and some of the concerns about that were raised. But
Thank you. Committee, is there a second on the amendment? Senator Thompson, sorry. Committee, any discussion on the amendment? Senator Baumgardner.
Thank you, Madam Chair. I would just like to remind the committee that if you look at that proponent testimony, including that of District Attorney Mark Bennett of the 18th Judicial District, he addresses in his second paragraph that it is an agreement to remove these different items, strike these different lines in the bill. And it just follows a continuing theme of what we heard from the other proponent testimony. So it is, in my view, what we see in this amendment is what the different groups came and agreed to for this particular bill.
Thank you. Committee, other discussions on the amendment? Committee then move the amendment, and you all have heard the motion. Those in favor signify by saying aye. Those opposed, no. The motion carries. Committee, do we have any other amendments? Do we have then a motion on the bill? Senator Baumgardner.
Thank you, Madam Chair. I move we pass out House Bill number 2516 as amended favorably for passage.
Thank you, Senator Gossage with the second. Thank you. Committee, you've all heard the motion. Those in favor signify by saying aye. Those opposed, no. The motion carries. We will now turn to possible final action on Senate Bill 534. 534 is enacting the Reduce Armed Violence Act to increase the criminal penalties for certain violations of criminal possession of a weapon by a convicted felon. And we will ask for a bill brief from the reviser, Mr. Thompson.
All right. Thank you again, Madam Chair, Jason Thompson, Revisor's Office. So Senate Bill 534, you heard, I'm trying to scroll back through my notes a little while ago. All right, this was on March 8th. You heard the bill. It was requested by the Attorney General's office. It does provide a new special sentencing rule. So you'll see that it's known as the Reduce Armed Violence Act. So that is provided by the whereas clause. The new special sentencing provision would be on the final 2 pages, pages 10 and 11. And it would provide that in addition to the sentence for, so the sentence for a violation of criminal possession of a weapon by a convicted felon would be presumptive imprisonment and would be served consecutively to any other term of imprisonment that's imposed if the trier of fact makes a finding beyond a reasonable doubt that 2 things happen. 1, the weapon the offender possessed during the violation was a firearm, and 2, such firearm was possessed by the offender during the commission of any violent felony. And violent felony is then defined to include a number of offenses that are similar to what's known as the felony murder rule, these as inherently dangerous felonies and similar things, although some of those offenses have been removed from this list, so it's not a complete reflection, but that is sort of the model that they used. And be happy to answer any questions.
Committee, questions for the reviser? Seeing none, are there any amendments or discussion on the bill? Seeing none, then do we have a motion? Senator Baumgartner.
Thank you, Madam Chair. I think we'll all remember the testimony we had from retired Master Deputy Moe and Detective Jamie Miller with regard to what they're seeing as far as a rise of very dangerous, very violent gang involvement in our state. So I move we pass out Senate Bill 534 favorably for passage.
Committee, second from Senator Thompson. Thank you. Any discussion on the motion? Seeing none, yes, excuse me, Senator Haley.
Thank you, Madam Chair. And I guess mine is more of an editorial briefly on this bill and the concept. Traditionally, I've been extremely concerned about bed space impact and the increase in our prisons for any particular measure. I've been very slow to support measures where we're going to incur significant increase to what's an already overcrowded prison bed space. Secondly, I should mention I am concerned still about the term of possession during the commission of a crime. That if in fact a weapon is possessed, if it's on that felon's person, and what it does then to add to the stacking effect with a consecutive sentence that would be added, and that if I were going to nitpick, we would find some kind of way to ensure that the possession was more active, I guess, in the commission of this crime for this stacking effect. But I want to say that the proliferation of felons in possession or who implement or who have when they shouldn't have a weapon at all, which is clear, it's the bright line test already in current law, is a concern that we have across many communities. And if I'm going to err in the rationale of how we add to our already overcrowded prison systems. If I'm going to err on what the definitions between possessing, brandishing, discharging a weapon would be, this would be where I do, because it's clear that we need to send a clearer signal to those felons that they shouldn't have these weapons and they shouldn't be committing these crimes. So, oddly as it sounds, for those and other reasons, I support the bill. Thank you, Madam Chair.
Thank you. Committee, other comments or discussion? Seeing none, then you all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. Committee, we will now turn to possible final action on House Bill 2473, removing the requirement that all district court judges in Douglas County serve on the Board of Trustees of the Law Library. And with that, we will ask for a bill brief from our reviser, Mr. Thompson.
Thank you, Madam Chair. Jason Thompson again. So this is the bill brought to you, introduced by Representatives Heiberger and Neely. Went through House Judiciary and passed the House 121-0. You heard testimony from one of the Douglas County District Court judges that current law requires all of those judges to serve on the Board of Trustees of the library, the law library in their county. Currently, there's an exception in the law for Johnson and Sedgwick counties only. In those counties, 2 judges serve on the board, not all. And Douglas County is requesting that they be added to that exception so that only 2 of those judges have to participate on the board.
Committee, questions for the reviser? Seeing none, then do we have a motion? Yes, Senator Wilborn.
Thank you, Madam Chair, for both accounts. I move House Bill 2473 out favorably for passage.
Thank you. Do we have a second? Senator Thompson. Committee, you all have heard the motion. All those in favor signify by saying aye. Those opposed, no. The motion carries. We will now turn to possible final action on House Bill 2508, requiring retention of fingerprints by the Kansas Bureau of Investigation for participation in the federal Rat-Back program. And with that, a bill brief from the reviser.
Thank you again, Madam Chair. Jason Thompson again. House Bill 2508 was introduced by, or requested by Representative Patton on behalf of the Kansas Bureau of Investigation. Went through House Judiciary, passed the House 115-6. Excuse me. You heard from the KBI representative that the current Rat-Back program is a program that allows an entity that is entitled to submit fingerprints and receive a person's criminal history record information to submit a request to be in this program that gives ongoing notifications of entries into the criminal history record so that it's not a one-time check, it's more of an ongoing check. The bill would put into statute a number of things the KBI is currently doing and also do some compliance with federal law and federal requirements related to participation in this program. Criminal history record information, as you recall from the hearing and from other experience in here, is highly sensitive, highly protected. It's limited to only certain individuals, and there are a number of requirements in here that that deal with how you submit the request to receive the information, the fingerprints that are required, how you submit your indication that you are no longer allowed to receive the Rat-Back, what the KBI does to close off those who are not allowed to receive information, and a number of those sort of provisions are in there too.
Thank you. Committee, questions for the reviser? Seeing none, is there a motion? Senator Gossage.
I would first just like to state I'm one of the few Americans that have no fingerprints. It's a true story. So I would move that we pass House Bill 2508 out of committee favorably for passage.
Thank you. Is there a second? Senator Bowers. Committee, any discussion on the motion?
I would just
Yes,
like,
Senator Thompson.
I would just like to say that Senator Gossage must have an easy time cleaning up furniture and stuff with no fingerprints. Pretty easy to do. No, that's very odd. Thank you. I'm sorry.
Thank you. Committee, you all have heard the motion. Those in favor signify by saying aye. Those opposed, no. The motion carries.
Just left to print on this one.
Committee, want to bring your attention to, I will be asking that the Kansas Judicial Council take a look at House Bill 2366 and regarding the jailhouse witnesses, and also announce that we will have a hearing on 2517, which is transferring the responsibility to certified drug abuse treatment providers that participate in the certified drug abuse treatment program from the Department of Corrections to the Kansas Sentencing Commission. Our intention is to hear that tomorrow, and it is within the 24 hours to submit testimony. So we will allow that testimony can be submitted until 8 a.m. Tomorrow there were, two proponents in the House, and so hopefully we will get that testimony in. We are running out of days and time, so the notice is short, and we will confirm that we will have that. And there is a question from Senator Baumgardner.
Thank you, Madam Chair. Yes, my question is about House Bill 2366. You indicated that, so are we going to vote on sending it to the Judicial Council? I'm surprised because that bill, I just pulled the folder and it passed out of the House last April 123-0. So that was not deemed a controversial bill, at least in the context of the House. I'm curious why it would need to be referred. I mean, we did have a full hearing. I see we had three proponents in WebEx. We had 4 proponents in written, and we did have only 1 opponent on WebEx.
Thank you for the question. It would provide a full opportunity for a vetting with our prosecutors as well as defense counsel. It is items like that the Kansas Judicial Council is frequently reviewing when asked to, and would be a good resource to make sure that this piece of legislation is properly reviewed. Thank you for that. And with that, committee, we are adjourned.